We just spoke about school choice with former Senator Joe Lieberman, and now there's a religious liberty story that you likely missed out of South Carolina. Private religious schools are asking a federal judge to eliminate a ban on public money going to faith-based schools. So let's go deeper into this. John Malcolm joining us now is the vice president with the Institute for Constitutional Government at the Heritage Foundation. Good afternoon to you, sir.
Great to be with you.
Now, let me ask you, there's a growing debate over whether there is a definitive separation between church and state, but this would appear to be a landmark case if this ban's overturned. So what exactly is at stake here?
Well, so the Bishop of Charleston, South Carolina, and a group of private colleges and universities have filed a lawsuit in federal court challenging a ruling by the South Carolina Supreme Court that barred the state from distributing funds that came from the COVID relief bill to religious institutions and to private schools. South Carolina has, as 35 other states have, what's referred to as a Baby Blaine Amendment. That prevents money from being distributed to religious institutions of any kind. South Carolina also bars distributing government funds to private schools. The reason it's called Blaine is named after former Speaker of the House James Blaine, Republican from Maine. He went on to become senator and a Republican presidential candidate. He tried to get a constitutional amendment banning federal funds from going to private religious institutions. He was known to have severe anti-Catholic bias. That amendment failed at the federal level, so it didn't become part of the U.S. Constitution. But 36 states enacted what are referred to as Baby Blaine amendments. South Carolina is one of them. And this is a direct legal challenge to the constitutionality of that provision.
So, John, how do you respond to people who are now concerned about the blurring of the line between church and state?
Well, look, there are some people who believe, wrongly in my opinion, that there's supposed to be a strict wall of separation between church and state. That language comes from a letter that was written by Thomas Jefferson, who wasn't even around Philadelphia at the time the Constitution was being drafted. The Supreme Court has already said that if it's a neutral program, if it isn't just tailored to directly benefit religious institutions and nobody else, that it does not violate the Establishment Clause. And in a couple of cases over the last couple of years, they have said, and if you do discriminate for a neutral program against religious institutions, that would violate the Free Exercise Clause. They held that in a case last year called Espinoza. And so the question is, does Espinoza reach this kind of a provision, which not only bars private funds to religious institutions, but also private schools? That's a nuance in this case. But I think that the South Carolina's Baby Blaine Amendment is likely to be struck down.
Now, if this case goes to Supreme Court, there's a strong conservative majority on the court. Does that automatically mean that this plaintiff will find justices who are receptive to this message?
Well, I think it's likely that they will find justices that are receptive to this message. There are 6 Republican appointees on the court now, and although a couple of them waffle on some issues, they've been pretty solid on religious liberty issues. In fact, recently they've issued a series of rulings, for instance, doing away with governor mandates limiting the size or prohibiting houses of worship from having in-person services. And the addition of Justice Barrett has been the deciding vote on that issue. So certainly there is a core of justices on the court now who care an awful lot about the Free Exercise Clause in the First Amendment.
And John, let me ask you, how do you see this case ending up?
Well, it's before a federal district court judge in Charleston at the moment. He has promised a ruling quickly. And then if there is an adverse ruling, whichever side loses, I expect that there will be an appeal. There is a time limitation in terms of when these funds have to be distributed. So that will put some added pressure on the courts of appeals and possibly the Supreme Court to take the case. But I think that it's likely that this challenge is going to prevail, but we'll see.
Okay, I want to bring in now Austin Ruse. He's the author of Under Siege. He's going to join us, John. Now, that's Under Siege, no finer time to be a faithful Catholic. So let's broaden the conversation a bit, Austin, to the Supreme Court, something we were just touching on a moment ago. We're 1 month into President Biden's 6-month study of changes to that court, including court packing and term limits. Austin, this is something that the president, while running, said he wouldn't do, but do you see anything meaningful getting passed here?
Well, I don't know if we'll see anything meaningful getting passed at this time. I mean, I think we're protected by a large body in the Senate that would oppose that. But with this commission on court packing and the verbiage of the president, I can very well see that this will be something that they will be flogging for the next several weeks, months, and even years.
So what do you think is the most what do you think is the most important lesson learned about religious liberty that maybe people aren't thinking of when it comes to, you wrote a whole book about faith in the public square?
Well, you know, the other side of the religious liberty argument, the other clause in the First Amendment is the Establishment Clause. And I argue in the book that starting in 1962, that an entire new religion has been incorporated into the federal government. Prior to 1962, well, in 1962, the Supreme Court determined that the object and purpose of government must be secular. Prior to that, there was a long-term healthy debate in this country between what may be called the providentialists and those who would be the seculars. So from that moment on, the seculars have had the whip hand in the Supreme Court and even in the federal government, such that at this time, a mile from where I sit, there's a grade school that teaches children new religious dogmas like sex is assigned at birth and boys can be girls. These can only be looked at as religious dogmas because they certainly aren't based in science. But this is the new religion that has been established and is violating the religious freedom of other denominations, Catholicism, the Protestant churches, and all the rest.
And John, let me ask you, you specialize in this as well. What's something that people just aren't thinking of or aren't focusing on when it comes to religious liberty?
Well, I think that Austin is right that the pendulum swung away from the sectarians to the secularists in the 60s and now appears to be swinging back. I think the biggest canard is that there has to be a strict separation between religion and government. Government can accommodate religions. It just can't establish an official religion, and it can't give money, at least under current Supreme Court jurisprudence, only to religious institutions at the expense of other secular institutions. But the idea that somehow any money going to a religious institution is unconstitutional, it's just not true, and it never was true.
All right, all the time we have for now. Austin Roos, John Malcolm, thank you so much for joining us.
Good to be with you.
Thanks for watching the Heritage Foundation's YouTube channel. With more than 500,000 members, we are the nation's largest conservative research and education institution. We believe the principles and ideas of the American founding are worth conserving and renewing. Please help us further our mission by subscribing to this channel and sharing our videos with your family and friends.